Beloved Creator, thank you for this new day and for bringing us together. And we ask that our numbers be strengthened and our messages heard as we go into this week of activities. We acknowledge the importance of keeping our connection to you active as we go about our duties. Thank you for this new day and for your guidance in creative ways to address the issues at hand, important issues with your help needed. And so it is.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. This is another 28 and a half minutes on cable TV, informing you about what's going on with our sheriffs. Our 36 sheriffs on Oregon that do not have a proper oath, do not have their bona fides in order. The office of sheriff is vacant in every county. The person sitting there does not have the authority. They haven't done the work. And it has to cease. And this is part of the effort. I want to bring forth a little information. I have it here. I can bring it up and read it. I'm putting this document together because of what's going on in Yamhill County. It's insane. So the two-part is probably to the municipal court for Newburgh. I'm not sure yet. But basically what happens is jurisdictions assume responsibilities they don't have. And until you inform them, they will continue to usurp. So this is what I'm getting together for Charlie to go through and clean it up and give it a cause number so we can use this Tuesday for Michelle. I'd like to read it. A third-party intervention by a clerk from a higher court, the one Supreme Court on Oregon, Article 3, Amendment 7, Civilian Common Law Court of Record claiming original jurisdiction, with Article 7, aka Article 1, Section 1, our Oregon Statewide Jural Assembly and Social Compact. I'll go back and flesh that out after a while. Declaration of fact, : the woman known to our court as Michelle on Oregon Hendrickson is not in your jurisdiction, and a claim of cognizance in this and any other matter of the state versus one of us on the land and soil jurisdiction. We deny you standing, status, venue, law form, and or jurisdiction over the body, mind, spirit, flesh, blood, soul, man or woman with our progeny on Oregon, the state, among the several states in our union. Consider these facts. 1. Living testimony in the form of an affidavit of, truth, properly done, becomes a fact in 30 days without rebuttal. We have 6.75 years without rebuttal. We implemented Ex parte Milligan, Article 3, one Supreme Court claiming original jurisdiction, found in Amendment 7, Civilian Common Law Court of Record, Article 1, Section 1, in Oregon, Article 7, Jurisdiction, the Jural Provisional Government on Oregon, November 2022. Signed, sealed, stamped, witness, proof of service, published at www.orsja.org, YouTube, Brighteon, 3 Cable TV, Portland. Notice and demand to the agent is applicable to the principal and so forth. Michelle on Oregon Hendrickson, identified here, is a woman not in your jurisdiction. She, and by extension, Jural men and other women and our progeny are sovereign on Oregon. Therefore, our court demands jura summa imperii for Michelle on Oregon Hendrickson and others to follow. So, for those among us that don't understand all the articles, amendments, and numbers in Roman numerals, I'll go back and go over this a bit. A third-party intervention. This is what the clerk of this higher court is doing. Now, when you read Article 3 in the United States of America's Constitution, circa 1859, the actual Constitution, jure, J-U-R-E, sometimes known as de jure, that group. So in Article 3, that's the only place in the Constitution where a man or a woman with our progeny can find remedy. It's not in Article 1, and it's not in some other court. That court, Article 3, is the court where a man can find remedy against the state, specifically any one of them that go against us. And then they corrected what was not written in Article 3 in the Bill of Rights when they wrote the Amendment 7. And in Amendment 7, it specifies that it has to be a jury trial, and it has to be in all matters in common law where the value is over $20. Anything less than $20, judges do. Over $20 in value, it has to be done by a court of 12, a jury of 12, making that decision. And that decision has no appeal, in fact. And that group, that entity, was made by the social compact of Article 1, Section 1 of Oregon's Constitution, circa 1859, in June 2018 by the people in the Oregon Statewide Jural Assembly in a social compact. So the court exists, and it has existed for 6 years. What we're doing right now is bringing the fraud of Article 7 amended to the forefront of the Oregon consciousness through cable TV, our publication, Oregon de Jure Journal, website, www.orsja.org, and our affiliations and connections with all those that are interested in a constitutional Republican form of government on Oregon and the other 32 states. So right now, our sheriffs, seem to be participating in a stonewall action of refusing to come to grips with the reality of the situation. When it's proven beyond the shadow of a doubt that the state of Oregon, aka all caps state of Oregon, the Salem oligarchy, is a crumbling mess. They can't put forth a government. They can't put forth a legitimate that will provide its bona fides. Secretary of State, the new one, Tobias Reed. We talked to his deputy, Michael. They have yet to provide us with their bona fides or to open the state archives. If you cannot support your claims, you fail. And apparently the state Secretary of State for the state of Oregon and possibly Oregon the state, we don't know. We can't see the documents. That bunch, the oligarchy, cannot prove their bona fides. And we need the sheriffs on all 36 counties to comprehend, not understand, but understand and comprehend that the sheriff is the senior executive on Oregon. I'm not going to answer that one. So when we're doing our confrontations, nonviolent, but definitely confrontations, they can be polite and meek. We're always meek, meaning we keep our weapons in our holsters. We have a problem with Yamhill right now. I thought it was going to be Marion or Washington or someplace else. It looked like it was going to be Lynn County for a while, but it's turning out to be Yamhill. And time after time, whatever it happens to be, turns out to come to a head in Yamhill. In fact, now might be a good time to stop this and look up the correspondence with Yamhill and come back. And I yield.
Hi, my name is Charlie White. I'm with the Oregon Statewide Jural Assembly. We've been working for quite some time, connecting with our sheriffs, or at least trying, to encourage them and actually require them to take a proper oath to the proper constitution with God and the laws of nature included. So this is my first appeal. Where are our sheriffs? Article 3, Amendment 7, Civilian Common Law Court of Record has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be there to assist seniors to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system, rather than ticketing them or supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us, the people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are our sheriffs? It is significant that they take a proper oath to the Constitution circa 1859 with its original jurisdiction. It's a necessity. that is to the people rather than to a corporation, and to our Creator, that is, with God included. Such a dejuration, an oath, is needed for there to be remedy in our system of governance. Let's get this ball rolling. It's just taking one of you to make a difference. It gets it started to assist in awakening your colleagues in sheriffdom. Let it be so.
Where are our sheriffs? Our Article 3, Amendment 7, Civilian Common Law Court of Records has made numerous visits and relentless communications to our county sheriffs on Oregon. Why? Because our sheriffs are our first protection against governance overreach. It is our county sheriffs that should be here to assist seniors to prevent their eviction from their home and all they possess. It should be our county sheriffs who protect and defend the people from a corrupt court system rather than ticketing them or supporting the illegitimate amended Article 7 courts. Our sheriffs seem to be avoiding any engagement with us, the people reaching out for a conversation about their refusal to see us. Contact requests are met with cricket sounds. Where are our sheriffs? It is significant that they take a proper oath to the Constitution circa 1859 with its original jurisdiction, that is, to the people rather than to a corporation, to our Creator, that is, with God included. Such a dejuration and oath is needed for there to be remedy in our system of governance. Let's get this ball rolling. It just takes one of you to make a difference to get it started, to assist in awakening your colleagues in sheriffdom. Let it be so.
I'm the old white man talking head for the Oregon Statewide Jural Assembly. This is for our sheriffs. It's also for our counties. I heard yesterday that somebody said it's the state for sure, but it's got to be the counties. And I disagree. And I disagree because I think it's the sheriffs and not the counties. And they're divisible. The county commissioners stand between the people and the sheriff in the performance of his duty. They're administrative, they should not be there. The counties are divisions of the state. The state is actually indivisible because it is one of the several states. So the counties is a play pretend that the people do to draw lines on paper and in the dirt. And it's not where the power is. The power is in the sheriff. And we have to have a constitutionally responsible sheriff. And I looked in Bouvier, looked up sheriff, looked up county, and sheriff is the executive of the county. And the county changes. On Oregon, we know we've only had color of law since November 8th, 1910, when they flipped us into de facto and we lost a constitutional Republican form of government. And when they did that, they stopped all lawful function of the state. Therefore, any county made after November 8th, 1910 is not a county. It's something else. And then when you look at the names of the counties are very much connected to the military of the federal post 1861. It's part of the U.S. military industrial bar attorney and so forth form of government. So any counties made after November 8th, 1910 are color of law, play pretend, But we have to deal with the sheriffs because the sheriffs are the ones that control the jail. The sheriffs are the ones that are charged with keeping the peace. The counties are not. The counties are a subdivision of a political entity, and it's something we strive to have properly done. And Yamhill's in the crosshairs. And we've tried several times to connect with the commissioners of Yamhill County in person, in their office, knocking on the door, calling on the phone, sending emails. This will be done caveat to will, probate and open court. It's going on now. It has been going on since we tried the sheriffs in Marion County on the sidewalk under our tent. We called an Article 3, Amendment 7, Civilian Common Law Court of Record, and we tried all of our sheriffs. Not one of them had a proper oath, nor the ability to bond. It's got to be proven, and they don't have it. The DPSST will not cooperate. The entire state of Oregon, its 89 legislators, its entire judiciary, and the current governor and the last governor, both our senators and one House rep, have all been found guilty. They have no honor. They've broken their oath. They cannot hold a position of trust. Now we're in the process of taking it straight to the sheriffs to solicit their proper oath. And we're doing it in common law. This hasn't been done, to my knowledge. The last common law case that a state was in was 1952 in Florida. The common law has not been practiced on Oregon for a really long time. In 1946, all of the attorneys that they could get together in the Attorneys' Treaty of 1946, you can look it up, they all got together and decided that they were going to have administrative law. They were going to have statutory law. They were not going to have common law anymore. And those that were going to do that were bar attorneys. And they have succeeded with Article 7 amended. Then they formed the Bar Association, the Oregon State Bar, 25 or 35, and then wrote it into the Constitution. This is what we have to have. This is what is required. And it's unconstitutional, illegal, and illegitimate. Now, you can't convince counties of anything, but you can definitely convince sheriffs of something. Hopefully, we convince them that they need to have a proper oath. And then a proper oath is subject to debate, but it must include certain things, and they're all written down. And we will have them on the state, regardless of where the county lines are drawn. We are dealing with Oregon, the state among the several states. And we have sheriffs, allegedly 36. But when you count senators, you only get 30. And when you count jails, you don't get 36 jails. Some of the counties share a jail. But it says in the definitions of Bouvier that a sheriff controls a jail. I guess if he controls one and shares it with a couple of more sheriffs, he's still doing the job. But the deal is, we cannot have a constitutional republic until those that are responsible for providing the constitutional republic do their job. Our job is to see that you do your job. And we will remind you continuously, all day, every day, until you do your job. And the more we identify that you're not doing, the harder it will be to catch up and do it right. This is specifically to Sam Elliott, Yamhill County. Sam, in Bouvier, there's 3 pages on habeas corpus. And I spoke to Mike, and Mike is not that well versed on the definitions of the Constitution. And he even said to me that he probably needed to study it more. Well, Amazon prints Bouvier in Troutdale, and they'll do it in 3 days, and you'll have your copy. And you'll know what the words in law mean. It's not what the bar attorneys say it is. It's what is written in the dictionary that defines the words. That has to be taken care of properly. You can no longer claim ignorance. It's not a good excuse. We've defined all of the faults. You know what they are, and you know what has to be done. So what seems to be the holdup? And I yield.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, "Just shoot me, Dad. This is what you want to shoot me." And they did. They shot him dead with his hands in the air. And I saw it. I swear to God, he was just walking with his hands in the air, and they shot him. And they shot him dead. And then after he was down on the ground, they shot him 3 more times.